Hi, everyone in the back. If you could please come forward. If you're going to join us for the afternoon presentations. Plenty of seats up front, and we have a video as part of these presentations. Unfortunately, we have a lot of light coming into this room, so yes. Hi, everyone. Hello. I was nice at first. That's right. All right, folks, we're going to start our afternoon presentations. There are plenty of seats up front, and we do have a video as part of these presentations, so I'd recommend you take them. We have a lot of light in here. Okay. Before I bring on our presenters, all right, folks. If you didn't hear me before, we do have a video as part of our afternoon presentations, and there are plenty of seats up front. Our projection is a little bit obscured because of the light, so feel free to join us. 4 seats up here, another 3, 2. So please feel free to join. Before we bring on our afternoon presentations, I did want to give the opportunity for a few words from our sponsors. So up first, Jamison Dempsey from Kelly Dry Warren LLP.
Hi, everyone. My name is Jamison Dempsey. Thanks a lot, Phil. Brief background on me. I graduated in 2011 from Brooklyn Law School. Professor Herman was one of my professors. I learned the Fourth Amendment from her. No greater expert in the country, and so I feel blessed. Jonathan Askin was also my professor and encouraged me to go to Washington, D.C. To pursue a career in telecommunications law. Right now, I'm working for a firm called Kelly Dry & Warren. Kelly Dry & Warren is one of the platinum sponsors of this hackathon. Kelly Dry & Warren has been at the forefront of innovation in the telecom sphere since the 1996 Act. We represent lots of disruptive companies. We represent lots of innovative companies in the telecom sphere. Jonathan knows because he worked with many of them in the early days. Right now, we're focused a lot on issues of privacy, and that's why we care a lot about this, not only legal hackers in general, but this hackathon here. We feel really honored to be part of what I think is the first international legal hackathon, and also perhaps the first international privacy hackathon. So this is a huge event. We're really honored to be here, and we're excited to see what comes out of it. So thank you very much.
Thank you, Jamison. And one more word from our sponsors. We have Josh Lennon from Clio.
Hi, everyone. Thanks for having me here. My name's Joshua Lennon, and I'm the lawyer in residence at Clio, which is an odd position where I help with legal scholarship and translation from lawyers to developers and back again. So it's a great way of reaching out to the technical community being here, so thank you for having me. A little bit of my background. I graduated in 2008 from St. Louis University School of Law. I now live in Vancouver, Canada, so you never know where a JD is going to take you. I get to travel all around the world now, meeting with groups like this and speaking and talking about where law is going. And quite frankly, we're going a lot of different places. If anything today, we've seen that so many people contribute to not only how the law is formed, but how the law is enacted and how the law affects our lives on a daily basis. So it's important to see these groups coming together. I want to thank Phil and Dan Lear in particular for allowing Clio to be a part of this. And we look forward to continuing to contribute and working alongside all of you guys. Thank you.
All right, so without further ado, I'd like to introduce Susan Herman, who, in addition to being a professor at Brooklyn Law School, is also of constitutional law, as Jameson just mentioned, is also president of the American Civil Liberties Union. So it doesn't need much more introduction than that. So Professor Herman, please come up.
So thanks to Phil and to Jonathan for inviting me here. This is my first ever hackathon that I've attended, and I'm really learning a lot already. I think this is really very cool. I'm not going to talk for very long because I'm looking forward to hearing what Judge Aiken has to say, especially because Judge Aiken is by way of being one of my heroes. I wrote a book about the impact of the war on terror on ordinary Americans, right here, Taking Liberties. You could order it on Amazon should you want to. And in one of the chapters, I feature a decision by Judge Aiken, which was really an excellent decision, one of the very few, about constitutional limitations on the Foreign Intelligence Surveillance Act in connection with the case of an Oregon lawyer named Brendan Mayfield. So, thank you, Judge Aiken. What I wanted to say, since this is Data Privacy Day and you're talking about how to get into problems that seem to be not particularly vulnerable to the traditional legal strategies, is that the ACLU has been noticing, especially since the fall of 2001, that there's a pretty big threat to data privacy in this country called the federal government. I'm sure I don't need to tell you about this whole world of the NSA just scooping up all of our telephone calls, et cetera, et cetera. If you don't know enough about that already, I don't know if any of you have seen this, but the ACLU did a great little video in connection with the holidays called "The NSA is Coming to Town." It features a lot of people in Santa Claus suits. You can't watch it now because you do need to listen to the words. They know if you've been bad or good. So I recommend that to you if you just want a sense of the scope of the problem that we're dealing with. But it's not only the NSA scooping up all of our telephone calls, etc. It's the rest of the Patriot Act, which provides that the government can find all of the information about you that's in the hands of third parties, as in standing. We're not going to hear your claim unless you can prove to us that you personally were subjected to covert surveillance. You see a problem there? Okay, the whole point of a covert surveillance program is that they don't tell you. So there's a great big catch-22 here. So we kept litigating this, and mixed success in the courts below. There was a wonderful woman judge in Detroit who ruled for us. But most recently, the Supreme Court ruled against us in a case last term called Clapper versus Amnesty International. Amnesty had been challenging the government, spying on their connections with their London office, and just probably would really have the authority under these laws to listen to practically everything that they talked to with their London office about. So the Supreme Court bought this, oh no, you don't have standing to challenge it because how do we know that you've been subject to covert surveillance? So then came Edward Snowden. And now we know that probably we all have standing, because probably we're all being subject to this. So we tried another lawsuit right after the Snowden disclosures that Verizon and so forth are just turning over all of our phone call material and so forth to the federal government. And that case is called ACLU versus Clapper, because we are a client of Verizon Business Systems. And it seemed to us that people often ask, well, why should I care what the government knows about me if I'm not doing anything wrong? Well, I have a whole section on that in my book. But to give you a small example, who's going to call the ACLU if they're a government employee who wants to be a whistleblower, or a student who wants to challenge their school because of their censorship or LGBT bullying? Who's going to call the ACLU if they know that in the government data banks there are records of every call to and from? Oh, you called the ACLU number on this day and talked for 5 minutes, and someone called you from the ACLU 2 days later and talked for an hour. How interesting. So one of the whole theories of this is it's only metadata. Who cares? It's only, only metadata is nonsense. If you're interested in this, there's a really interesting affidavit in the ACLU versus Clapper file on our website by a computer scientist named Edward Felton at Princeton. And he talks about how metadata is actually more useful to the government than the content of conversations. You're nodding, you're the techies, right? It's structured, they can search it, and they can find out an incredible amount. So, that's the world, and we have not yet, gotten a whole lot of control over this by litigation. Litigation's been a hard path, because as I said, most judges do not want to rise up and say, wait a minute, what's going on? So, we've also tried lobbying. There weren't any hearings at the time of the Patriot Act. The government didn't want to hear whether there was another side to all the powers they were unleashing. But since then, we've been trying endlessly to try to get Congress to do something. After the Snowden revelations, it's beginning to seem like they might be interested in some improvements. We're supporting a fix called the USA Freedom Act. Check it out. It's also an acronym like USA Patriot. It has with online monitoring and electronic eavesdropping. Somebody figured out a whole acronym there. So, that's a possible thing that might happen. So we've been spending a lot of time in Congress trying to get them to stand up to all of this and say, wait a minute, over 10 years after 9/11, could we at least find out whether this massive surveillance is doing any good? Are we just giving up our privacy and our rights for nothing? And, what's it for? And everyone is saying, oh, well, we can't tell you, just trust us. Not good. We've also been lobbying the White House. I was at a meeting in the White House a few months ago. A lot of our staff has been spending a great deal of time with the president and his staff trying to get President Obama to remember what he used to teach when he was a constitutional law professor. Okay, so, we made little progress again, not as much as we would have liked. So there was the Freedom of Information Act. We've tried a lot of public education. That's why I wrote this book, to try to explain to people why it does matter to you, not just them. But nevertheless, this has been an extremely different problem. So the thing I wanted to talk to you about today, because we've been trying to sort of hack the problem in our own way. We haven't been just using technology about this, but we've been trying to find different strategies. And it turns out that as opposed to the traditional, we challenge the government and constitutional law and the courts and the lobbying, et cetera, it turns out that the key to this problem, I think, is with private industry. Okay, quite literally, because the private companies do have the keys to encryption, and in a massive way because the government could not gather all this information from the telecommunications companies and internet service providers without cooperation. Some of the companies have been turning over information because they've been required security letter from the FBI. They show up and say, we want information about one of your clients. And Nick said, wait a minute, what about the Fourth Amendment? If there's no court order here, how come? So Nick came to the ACLU, and the first lawyer he met, he said to the lawyer, so if I challenge the government on this, is someone likely to put me in a sack and drag me away? And the lawyer he talked to said, actually, we can't tell you what's going to happen. And Nick said, I'm going to do it anyway. So one of the consequences was that for 6 years, Nick was not allowed to tell anybody that he was the John Doe who had brought this lawsuit. Imagine that, right? His girlfriend ended up breaking up with him because she had the feeling he was hiding something from her. He had to lie to her when he'd go in to talk to the lawyers. He had to hide the court papers in places where she wouldn't look because he was not permitted on pain of federal prosecution to tell anybody that he had brought a lawsuit, that he had received a national security letter. He always knew he never intended to tell anyone the details of what the government wanted to know. And he respected that could be secret. So I have a very nice picture that Nick took for my book of himself holding his national security letter. So since then, what Nick has done, I'm happy to tell you that thanks to one brave federal judge in Manhattan, Victor Marrero, Nick won part of that case and at least managed to make some inroads into the gag order, which was you're not allowed to tell anybody that the federal government has asked you for information. And this is, hundreds of thousands of people had gotten these gag orders and the national security letters, and Nick was the first one to say, wait a minute, I want to challenge this. So what Nick is doing now, the reason that maybe some of you have met him, is that he is now a client of Jonathan's Blip Clinic, and he is running a little company called Calyx, C-A-L-Y-X, and his chief goal is to have this company be as privacy-friendly as possible. So he is totally into hacking this problem, right? He's really trying to figure out how you can use technology so that private companies can, in fact, protect privacy despite the government to the extent that they're able to do so. So there's example number one of sort of the connection with the private sector. Now, the other thing I want to tell you is that when I was at this meeting at the White House, there were a couple of other civil liberties and human rights people at the big table in the Roosevelt Room, but most of the people who were around the table, who the president really wanted to listen to, were from internet and telecom companies. Okay, and they were beginning to think that maybe it wasn't such a good thing to cooperate. And just say yes, sir, all the time. And the reason they were beginning to think this was Edward Snowden. Now that everyone around the world knows how permeable our internet is and how the government is just getting all this private data, there are people around the world who are beginning to say, well, wait a minute, maybe we shouldn't use American-run companies. Maybe we should start our own that's going to have better privacy protection. So people are beginning to fling around numbers like $80 billion a year. So, how's this for an argument? Not just privacy and liberty, but it's bad for business? Okay, that's where you start thinking maybe you're going to get some attention from the president and from Congress. It's bad for American business. We're going to lose our dominance over the internet and over a lot of telecommunication systems if we don't respect data privacy in some way. The other thing about the whole idea of data privacy, in addition to the dominance of internationally, is that now that somebody was mentioning the poll this morning about all the American people who really do value privacy, even though we might talk about is it anachronistic. So the other things that the companies were beginning to figure out was that this wasn't such a good thing in terms of their own customers. A lot of their customers were upset now that they knew this. Well, this was something else that the ACLU had tried, one of our many different ways to approach this problem. Back when we weren't getting much purchase with the federal government, when it came out that the telecoms were all cooperating, we tried going to state public utility commissions to say, okay, this telecom is licensed in your state. Look what they're doing with their customers' data privacy. Do you want to do something about that? So this was interesting. We had some state public utility commissions that were very interested in this. So Congress shut that down too. And the same law where they gave retroactive immunity to the telecoms, they also said, and forget state public utility commissions, it's a federal problem we get to decide. So the other thing we tried to do, and this was maybe premature at the time because people weren't aware of the extent of the problem, even though we were trying to tell them, is we had lawyers go to shareholders meetings of some of these big companies to say, wait a minute, look, this is your company. Do you really want to be doing this? Do you want to instruct your company to be doing something different? And to say to the government, wait a minute, do you have a court order? Why, how much, what? Well, after Edward Snowden, some of the companies are they've gotten there finally. Google, you may be aware, has now, they actually brought a lawsuit, and they've been trying to get the federal government to release them, to at least be able to tell customers more about their privacy policies and what information they're giving over to the government. So, it's something when Google and different companies are now on board, because this very much involves them, and they've been very complicit in making the internet so permeable. Sprint has over 200 full-time employees whose job it is to furnish government requests for information at all different levels of government. AT&T has 100. They do get compensated monetarily by the federal government, but major complicity. So let me tell you that the private control over data is not only about the surveillance area. Somebody was mentioning the Jones case this morning that the Supreme Court recently decided about GPS tracking devices being installed in cars. Well, you may know that what the Supreme Court decided is that the Fourth Amendment prevents the government from placing a device onto your car. But what the opinion clearly imagines would be different is if your car came with the device. Okay, then they haven't touched your car. The manufacturer has put the GPS device into your car. Okay, this is my own idea, and I don't really know whether anyone's followed through on it, but I was trying to get the directors of our Michigan and Ohio affiliates to go to the car companies and say to them, do you really want to do this, or do you really want to be able to say to your customers, we're a privacy-friendly company. We're not just, collaborating and making your car a way for the government to spy on you. So I think that would be interesting. And again, if consumers are interested, if it's bad for business, maybe we can get the private sector to be cooperating more. So that's my big idea, is that the private sector is very much part of the solution here. So if you are a programmer, whatever it is that you do, this is my version of see something, say something. Okay, if the government is collecting too much information and you think there's something that's happening that might be unconstitutional or illegal, don't just assume that that's the way it has to be. Think of Nick Merrill. I'll also tell you one more small story. The reason that you're all here is that you believe that one person can really change the world. Well, there were two lawyers in the ACLU office early on, after the Patriot Act and all, Jamil Jaffer and Amrit Singh. And they were trying to figure out, what do you do about finding out what the government is doing about all this? And they were the ones who had the idea of using the Freedom of Information Act and bringing lawsuits and forcing the government to give up this information. So a senior lawyer in the office said to them, oh, you're right. Any court is going to order the government to give up information that the government says is essential to national security. Lots of luck. He said, I'll give you a nickel for every page you get the government to turn over. Well, I am sorry to tell you that after the first 100,000 pages, that lawyer reneged on the bet. And again, part of what we got through the 100,000 pages is the Office of Legal Counsel memos on torture and all sorts of other things. So you're right that you can change the world as an individual, and that's why I think the whole spirit of this hackathon is amazing. It's your constitution, it's your law, it's your privacy. So the final thing I want to say is, in the words of Phil, a word from our sponsor. There are some problems, however, that need a bigger team. And I think that at least 90% of you in this room should be members of the ACLU if you're not already. So if you want to know more about what we're doing in this whole area of protecting data privacy, I invite you to the website, aclu.org, where you're just one click away from join. The basic membership is $35. Everybody can afford that. If you can afford more, of course you should be supporting us because you will want us to be there when you need us. So, because freedom cannot defend itself. Anyway, it's a pleasure to be with you today, so keep up your good work as individuals, but also remember the bigger picture. Sometimes it's going to just take a bigger team. Thank you.
Thank you, Professor Susan Herman, for those words. I hope he doesn't think I'm breaching his privacy by telling you this, but Nick Merrill is now happily married with a kid. I actually share a desk with him at my office in Soho, right across the river. If you want to know more about what he's doing, I'm going to try and get him here tomorrow for lunchtime presentations, which we'll schedule for 1 as well. But if you want to know more about what he's doing, he's at thecalyxinstitute.org. So now to completely change gears here. I was put in touch with Judge Ann Aiken through Dan Lear and Dan Katz through the reInvent Law crowd. You gave this presentation last year in New York? Yeah, so Judge Aiken has come in today to talk a little bit about a project that I think you'll find very interesting. It's with respect to, well, I'll let her talk about what it's with respect to, but she is here to ask for your help, your support, and wants to tell you a little bit more about this project that she's working on. So without further ado, Judge Ann Aiken.
It is beyond an honor to be here, and I can't say enough nice things about Susan Herman and as a professor and as president of the ACLU, and so it's my honor to get to meet her today and to present following her, but I can't resist but saying, I'm from the federal government and I'm here to help you, especially with that setup. And so I have to start with that. Let me tell you a little bit before I begin what I'm going to talk about. I'm here to pitch you. I'm here to give you a sales pitch and ask for your help. And when she talked about the bigger team, we're all on this team, and I'm going to hope that you're going to understand exactly what I'm requesting and why I really need your help and respect your help. I feel like I've been at the hat trick of legal technology events. I went to Law Tech when I arrived here at Dark 100, Wednesday or Tuesday, I don't even remember, from Oregon. And so I got to see the big displays and presentations over at the Hilton. Yesterday was just an astounding day at reInvent Law over at Cooper Union. The presentations were extraordinary. The talent, the opportunities, and the vision of all of you and other leaders in this field. So it was breathtaking. And then today, the privilege to come here and pitch this idea. Because right now we're at really moments of walking over some cliffs. And I want to talk about a problem that I see every day, and I want to step back a little bit. One of the things about life is sometimes it's just about the stars align and the right things happen for the right reason. But I have to tell you that a political science professor, someone who taught constitutional law, civil rights, and civil liberties when I was an undergraduate, changed my life personally and professionally. And I'm a product of public education through and through, and I'm a belief that really one person can make a difference. And if you persevere and you stay true to yourself and understand that work is really not work, it's doing the passion of your life every single day. Find what makes you happy and do it. Then really all that we're doing is moving the ball ahead for the next generation. And that's what I feel as a steward for the legal system as a member of the federal court. So I have the privilege of serving as the chief judge in Oregon. Like Little House on the Prairie, I'm Laura Ingalls Wilder from Oregon. You guys are in New York. It's the big deal here. So it's a huge honor to be sitting here looking up at the Brooklyn Bridge. I mean, I can't even believe this. It's astounding. So thank you for just giving me this chance to just simply come to New York and talk to some of the smartest leaders in the tech field. So here's my problem. When I went to the federal bench in now almost 16 years ago, we were guided by what are called sentencing guidelines. And so for about 20 years, just as a little piece of information, about 20 years, judges didn't have to know anything other than a risk assessment score, you know, how many crimes you committed and what kind of crimes, and you got X score, and a matrix that down the other side was you committed this crime now. And there was a little box and it told us where you fell, and the judge's discretion allowed the judge to sentence between, you know, like a dash, you know, like 42 months and a million months, but this a dash, and that was our discretion. And we could vary, and we could do massive opinions that laid out what our deviations might be. And we would go to conferences where they would literally recite to us which circuits were having deviations of their, failing me? I know, what did I just do there? Well, this is this gonna play? This is what we had. Bishop.
650,000 people every year are released from a jail or prison facility of some type.
Regardless. The question is, as a system, do we bring them back with or without the ability to be successful?
Systems do a terrible job of taking care of people, of individuals. You just become a number and they just, push you through.
We know what works.
The more I watched them and I really listened, and I really understood after the first session of setting in that they actually cared.
Here I got the prosecutor, the judge, the PO. It's not how can we screw you or lock you up. It's what can we do to help you? What can we do to make your life a little more easier? I never had that.
We know nothing happens without leadership. Our communities are ready for change. It's time for a new era of leadership from the bench. This is not about activism. It's about leadership for our communities. Programs are already working around the country. We know there's urgency. We know what works. It's time to lead right now.
This was our system. We called it a catch and release and catch system. And the revolving door is such that you release people out of prison. They'd served a 15, 10, 12-year sentence. They'd come out. The world had changed dramatically. They couldn't function. They had no services. The probation offices didn't have a mission to assist people other than to test them, drug test them, and address their issues in almost a punitive way. And after 2 or 3 dirty UAs, they would come before the court, and then our option would be to send them back to a federal prison, which is our most expensive alternative. So that was our system. These are the numbers nationally, and I'm happy to say that we're starting to come down, but we're the most incarcerated industrial nation in the world. It is unbelievable. It's just extraordinary. But the line I want you to look at is the population under supervision, because people are coming out under supervision and they're not getting the assistance that they need. We don't have the resources, and they're making their mistakes, and then they're going right back to prison. So those numbers are going to cross, and they're going to become more and more complicated and difficult cases. In Oregon, we only prosecute and we handle in our system the highest risk offenders, and we have some of the highest risk cases just because of the nature of being on the I-5 corridor. So the drug trafficking is extraordinary, but you can see our numbers are growing up dramatically and quickly. So we convened a summit, and we concluded that we could do something better, and we decided that we as a system had to understand evidence-based practices, which those of us who had been in child protection services and in family and human services understood that we had to address those risk need predictor scores. So we devised and wrote, spent a long time reading 4 bodies of literature and putting the best practices in place. We took the whole system upside down and we built teams. So our reentry team consists of the judge, the prosecutor, the U.S. attorney, the public defender, treatment providers, and the probation officer. I am not in charge. I go to every single session. I have missed maybe 3 sessions in almost 10 years. We meet every single month around a conference table with all the participants, highest risk offenders in our system, to address their issues. And that's our model, because we look at what do we need to do in criminogenic research to address the needs and keep people out of the system. And what we've concluded is that it's almost a medical model. It's our ability to identify the symptom, drill down, figure out what service is needed, and then our job, when they tell us what they need, is to get it. And what I will tell you is our outcomes are starting to be extraordinary, and you're going to learn over time how successful we've been when we started this so many years ago just as a project in Oregon, because we weren't satisfied with the way in which things worked. So I want you to understand that we have a system now where we're looking at data, and when you just do a surveillance system only, we have a reverse impact. When we couple service with treatment, and that's just cookie cutter, you put some treatment out there and it's not tailored, you have some effect. And then when you start to couple it with risk-need responsivity, when you respond appropriately to what their risk predictors tells us they need, whether it's mental health, drug and alcohol treatment, housing, family services, education, you name it, when we start to identify those issues, we start to have a dramatic effect. Next, Attorney General Holder, this administration has for the first time really committed to understanding that we have an overrepresentation of minority problem in the juvenile facility systems as well as prisons, and all you have to do is read Michelle Alexander's book, The New Jim Crow, to understand the magnitude of that particular problem. And so we have to do something different. And at this point, it's really a collective issue of getting the data. Otherwise, we're going to continue to have the pendulum swing from incarceration over to something else and back and forth. But we have to have something that's smarter. Our next, I would tell you Judge Sifton of the Eastern District of New York, that's Judge Sifton, quietly started to have people come back to his court and to start addressing those issues on supervised release. And I always pay tribute to him because he had an unbelievable probation officer who I've become friends with over the years, and she was committed to assisting him by providing those auxiliary services for him. But that's 2002, and look where we are now. We have programs across the country at various stages, and one of the things about the criminal justice system and judges generally is we're all kind of competitive. Everybody has to have the best things. So everybody's working now to see if they have a better, more complicatedly appropriate program and more resources, so it's actually been a good thing for the system. So our system already allows us to do some of those things, and what I would tell you, what's really important to me is that we build these systems in a way that reminds everybody we actually have to have the funding. And so when Susan talks about putting a team together and addressing complicated issues, it takes a team. Because right now, the budgets of the courts and the budgets of institutions that provide these services are under siege. And at this particular point in time, it doesn't do me any good to be a judge on the federal court if I can't help people with the resources that I need to serve them. So we know what's working. So I want to tell you, just because it plays off what Susan has to say, is in our reentry team, we go into that session generally with a pre-briefing. I know everything, I follow every one of my cases, I know them inside out. We go in with barely a pre-briefing, we go in, it's their time. It's a peer support program, it's around the table, and we're there until they're done talking, and it's built on 3 fundamental principles: truth, trust, transparency. We know everything about them, and we set a much higher bar, and we are absolutely committed to their participating with us in the same fashion in which we participate. And as a result, we meet them more than halfway, and we meet them in a capacity that in the federal government, we sit there oftentimes till 7 or 8 at night to address some of their complex problems. So here's what I need. Here's why I'm here. What's really, really holding us up. In the federal system, we don't have enough probation officers and individuals to do the work. So what happens is we respond usually when there's negative behavior. What I have really wanted to pitch is a device, as simple as this, that we hand people coming out of prison, and it gives them the opportunity when they need help in real time to ask for help and to tell us so we can respond in an appropriate way where to go. Say, for example, a lot of folks get into a grocery store and they don't know how to make decisions about how to buy things. And if with a click of a button they can get some advice on what they need for formula for their child, as an example. Or they're starting to have something happen in their life and they're ready to use, and they need to talk to somebody today, not at 4:30 next Thursday. Our folks need instant responses. So our probation officer, they need something like this that responds instantly, and we get feedback to them and we get them where they need to go, or the assistance. And we also need the ability, and this is my tip to Susan, I'll get to the next part in a minute, is what we need to do is say, hold up your phone and tell us where you are. Just show us, oh, what are you doing there? You're not supposed to be there. Oh, let's see your eyes. Oh, I think there's a problem here, and then we could respond. It does two things. It helps people get an intervention when they're in crisis, but more importantly, what I would tell you from a criminal justice standpoint, it helps keep people from being re-victimized in the communities. Because once people start to make mistakes, the fact they might have to come back into court, they figure, why not just do all these bad things, because it's only going to get worse. So what we're trying to indicate is we can respond quickly and we can stop people from going down so fast. So that's sort of an idea about the device, but more importantly, what we have now is this. Now here's what I would call big government, big brother, right here on your ankle. It just tells everybody where you are. Now I like to, again, this is my tip to you, this is little brother. Little brother is a device here to help you, help get you out of the system and provide resources. And what we can do is have something that's really a quick device that we tap in and we can figure out exactly what they need, where they need. They can respond to probation officers, and in real time we can make a difference in their life. And what's really nice about it is they're coming out, and it's always about education. My goal to do better in our criminal justice system is to move money to education, because what I see in the courtroom and what I see in my probationers and my people coming out of prison is the failure of education. Really, some very, very, very gifted people who were not semantic learners, who had vision issues, had auditory processing issues. So we're using cognitive interventions and strategies that probably should have occurred back with brain research when they were 0 to 6, that we're now addressing when they're coming out and they're the most expensive individuals in our criminal justice system. But look at this. This is the most important thing. If we had the ability to have every one of our probationers, and mind you, this could be given to somebody coming out of a mental institution who's coming back into the community and needs to be regulated on their plan to return to the community, be mainstreamed. It could go to a child coming out of foster care. It could go to a child coming out of juvenile. What we have is we plug it in, we have data. We have the ability to take a look across a dashboard and figure out, where do we need to put resources? Is it housing? Is the big problem our people don't have any place to live? Is it the fact they can't get food? They're starving, they can't feed their families. Is it they don't have a job? How do we tailor their job prospects? And did they even know how to go look for a job? What does that data tell us? Right now, we do so much work based on anecdotal information. It's not productive, and it's costing the communities and you as taxpayers, and I'm a taxpayer, it costs us a lot of money to just guess where we should be spending resources. Now, these are 3 of our folks who graduated last week, and I have videos because it's always about the stories. But I want to talk to you about these 3 individuals because they are really complicated folks who deserve your attention. Andy, on your left, Andy's from Hawaii. Andy is an incredibly gifted product of a family that has academic after academic after academic, and he got sideways with methamphetamine and drugs, and as a result of that, he ended up being convicted of possession and delivery, firearms offenses, unlawful possession of firearm. He just was trashing his life. And it has to do with the fact when he was high one night, he ran over and killed an older woman. And basically, in an attempt to have a cop suicide, tried to be just shot down and killed on the spot. A really, really sensitive guy. We had him come into the reentry program. He was one of those individuals who just simply wanted to disappear and never have another person in his life. And through our work in reentry, we brought him out of his shell. We had a pro-social activity that involved him doing cleanup at a particular property. We worked on his education issues, where now I'm going to meet with his uncle who took him in and his family to help move him into a 4-year institution for education. He didn't even see himself with that possibility. But he changed, he went into mental health counseling, we got him all the things that he needed, and at graduation, his family sat in the audience and wept. And so we made a huge difference because it was the little things that get in people's way, and it was that sense of community that gave him a difference. And what I will tell you, and we have another presentation we're doing because we work on how to improve all the time, we text with them. I don't have the device yet, but we are willing to make our own cell phones known so that we can text when they need some help and support. And it's not the best way to do it, and it shouldn't be that that's our only way to communicate. Mary, 58, she was sentenced to 48 months for distribution of heroin, and the distribution and her use resulted in the death of her husband. And when she graduated at the ceremony, I read her letter that she wrote to the reentry court, where she said a day doesn't go by that she doesn't regret that she was the reason her husband died, and it was all about heroin. She's been a prostitute, she has done multiple forgeries, she's possessed, her risk assessment was moderate. But what I will tell you about Mary when she came out, she basically lived in an 8x4 room under a staircase. Her shame, her horror at what she had done just wanted her to be small. And she came to reentry court and she sat at the side, and it took us months to get her to really open up and start talking to us. She not only has been successful and she walked probably 4 miles from her residence to come and work in our pro-social activity, which was cleaning up a dental clinic. We had a 2.5-acre garden that we grew, and we did this pro-social activity giving 5,000 pounds of food. But you can't believe the devastation of some of these folks and the resources that make a difference just simply in their lives that will move them out of the criminal justice system. So her graduation now has her running. She's the house person at a recovery house, and she manages basically the lives of the other women in there because she has started to emerge as a person, and it has everything to do with people providing the institutional support she needed. And then Wes is an unbelievable story. I would have to say he's a fetal alcohol syndrome Native American from Warm Springs Reservation. He's 40. He has had a huge anger management problem. He's had any number of assaults. He's probably one of our highest risk offenders. Possession of firearms, substance abuse up the yin-yang, every single drug imaginable, and provided to him by his parents at age 6. So everybody thought there was no way we'll make a difference with him. Put a knife through a telephone pole instead of another person after having consumed a bottle of vodka, almost got him back in custody, but we took him. And over time, we have a cognitive skill test that we used, and we were able to finally get through to him to sit down and take the test because he so badly wanted an education. And when he was clean and sober and doing well with 3 kids on the reservation and a new baby coming, we thought it was worth the investment to help him. So we gave some skills to him. We sat back and just very simply said to him, Wes, you don't think quickly. If you take a deep breath when something comes at you and you can stop a minute, you have good reasoning skills. But every time you go from finding out a piece of information to 60, you make a bad decision. So we've practiced that over the year. He is now a graduate. He's back in school. He has understood that that's simply how he has to behave, and he's a different person. And I happen to have the governor's, we're doing a reinvestment model in Oregon, that's why this is so important. And the governor's staff was in there when he came in and broke down sobbing. For the first time, his father came to his circle, which was in the tribe, how he was supporting himself spiritually and emotionally. His father came in and said to him, I owe you a terrible apology. I'm sorry I beat all of you bloody as a parent. I'm so sorry I told you you were such a terrible person, and more importantly, I'm so proud of you. And for the first time, he was able to understand that he could cry because his father told him he just couldn't cry. So in the room, our treatment provider said, you know, Wes, this is the breakthrough you've needed for a long time, to have some forgiveness about your past. Because in the courtroom, what I tell people is, child abuse and neglect does not excuse people's behavior, but it explains almost every person I see. And so Wes had that breakthrough. He graduated. These 3 people really have never successfully completed much of anything. So what we've tried to do is celebrate people's success and then stay with them. But it's this connection to people that matter. So what I'm looking for is doing this. This will switch. You got to know hope. We know hope because we see it in the people we serve. And when you know hope and when you see it and when you believe in people, we're not going to solve everybody's problem, but we're going to do a better job. We're going to change the resources, and technology will help us spend our money in a cost-effective way, in an appropriate way, and it'll save your children and our children the opportunity to get their education in prison, because maybe they'll be able to get their education actually in schools. Because the way we're going right now, the cost of money and the cost of building prisons cannot be sustained. So in this moment of time, out in Oregon, I would tell you, you have judges across the country. Every single one of those little balloons represents a judge who has taken on this project across the country. And I'm here to tell you that if you're able to talk about designing a technology that we can implement as a model, which is how this all began, the kind of data that we'll be able to get will drive the agendas of budgets for years to come and give us a chance to do actually the kind of work we should be doing on the bench, instead of just moving files, but actually helping people. So I want to close with a quote, and I apologize, it's a little long, but I really feel I need to say it. The mood and temper of the public with regard to the treatment of crime and criminals is one of the most unfailing tests of a civilization of any country. A calm and dispassionate recognition of the rights of the accused against the state, and even those of convicted criminals against the state, a constant heart searched by all charged with a duty of punishment, a desire and eagerness to rehabilitate in a world of industry all those who have paid their dues in the hard coinage of punishment. We need a tireless effort toward the discovery and curative and regenerative processes, and an unfaltering faith that there is a treasure, if only you can find it, in the heart of every man. These are the symbols which in the treatment of crime and criminals mark and measure the stand-up of a nation and the strength of a nation, and are the signs and proof of the virtue within it. And that's Winston Churchill, 1910. It's Winston Churchill, when people pay their debt to society, when they come out of prison, they deserve better than what we're offering them. You have a chance to be part of a bigger team to make that change happen and do something that hasn't been done yet, and that is drive this discussion based on data and based on resources that actually will make a difference. So that's my pitch. Thank you very much for your time today.
So I just asked Judge Aiken if she'd be willing to come up and answer a few questions if anyone has a few.
So I understand the individual and societal utility of the mobile application proposal. In a privacy context, have you thought about what sorts of safeguards might be applied to protect the privacy of the person returning to society?
Well, I would tell you that these individuals who are coming out are under the jurisdiction of the court, and essentially because we have this huge umbrella of obligation to what their worlds are about. They're under a number of constraints. So the areas we're talking about are issues that they're obligated to comply with for their treatment, for their supervised release. And I understand those differences, and so we would be very, very thoughtful about how we would do that, and I would certainly want the industry to tell us where those boundaries ought to be. This would be a partnership. I understand that, but essentially we know everything about them anyway, and they tell us. So, but that...
You have the cloud knows everything. That's the dilemma. When it's the parole officer and the individual, there's at least a human filter touching the information. Now we're talking about uploading it somewhere where it has orders, whether it's access to metadata.
Except they have an obligation to fill out a monthly report which contain much of the same information that they self-report, and we keep those, and those files are there forever. This is maybe a little bit more, but they're still writing that information, and in real time it's basically the asking for help more than anything. So they're going to choose what they're going to put on the report, they're going to choose what they tell us in the courtroom, and they're going to choose to decide what they're going to write. So in all those functions, that's their choice. Because at any moment, we could say to them, boom, you need to go get a UA. So the fact that we are able to put where they are and ask them where they are and they don't turn it on, that's information too. So I would, and again, I don't have all the answers, that's why I'm here, and if there are safeguards, I would respect and appreciate why you have a concern and how that would shape.
I think they're very important to empower the issues that are, I see the potential to empower the individual.
Empower that. The other is an education tool. Most of these guys are coming out and they're overwhelmed by the fact that everything is run by a computer or by making a phone call and you can't get from here to there, or understanding how to work those systems, and those levels of frustration go right through the roof, and they overreact. And our goal is it's a teaching tool to start working with an intuitive device way up, in the prison, so that when they're coming out, they know how to use some of the materials. And when we tell them you can go online at the library and research X, Y, and Z, that's oftentimes where we send them, or the community college, it's not good enough. But this, in real time, we can respond. And basically, I've had probably 50 different districts out to look at our model, and including the sentencing guidelines, the Sentencing Commission. And they said to us, at every policy discussion we've ever had, not one of the issues that happened in this courtroom today has ever been talked at a policy level, because what really are the needs of the people, we spend all of our time up here talking about policy, but what the basic needs are solving just some day-to-day problems that they just can't get a handle on.
So if we can't hack this one this weekend, I think this is one we should start thinking about in hacking. Privacy sanctifying user-powered tool for felons and criminals. And
I respect the privacy approach and what you're looking at. And in fact, one of the presentations over at Reinvent Law was addressing the issues with regard to hacking in and privacy questions, and it was phenomenal. So I kind of think it's funny that I'm pitching you today of all days on this topic.
Thanks. And we did a little clip of this as part of the highlights of the event. We haven't videoed anything of you so far. So what I'm going to ask you is just so you know in advance, just for MIT, we do a fair amount of analytics and big data.
Yes, you do.
I don't look at some of your data sets, so I was just going to be a little bit of exact data would be helpful for information and out. So it'll be a softball question, but
Yes. Yes, and in fact, Dan Katz, I have to give a shout out to Dan Katz, who was a student of my husband's. I met him as an undergraduate, who's now really one of the leaders on Reinvent Law and the Reinvent Law Laboratory at Michigan State. But one of my favorite presentations is he has, and it's under his computational legal services blog, is called the MIT School of Law.
Exactly. So that's a perfect segue, and he's someone that we definitely track.
Thank you.
As it were. By RSS feed, not by surveillance. So Lena is a public law student, and I'm Dazzle Greenwood, scientist in MIT Media Lab's Human Dynamics Big Data Group, basically, and I'm a former lawyer. What we do is it's called computational social science.
Yes.
And our method is like that. What you referenced, we're applying computational legal science, similar to legal studies, but we're literally doing research-based studies, and we do an awful lot with personal informatics in other realms of economics and sociology and so forth. We have tons of phone data, tons of social network data, some of the data create models that are very insightful. So how can the legal team together in the research group at St. Madeleine looking very seriously at justice statistics, and of course there's contracts and practices, other areas of law. In justice, we're reviewing just zero justice statistics data that they have.
Yeah.
And taking a look at the U.S. State Sentencing Commission data sets as well, which are good. And just thinking back to my days, I was a government lawyer for a while, and some prison systems and a few other things with Herman. And he struck me when we received the data and the app that's actionable. Right on
Recidivism app, yes.
Exactly, but I wanted to just ask you to talk a little bit about what seems to us, reasonably involved for people, but seems like such a tangled mess right now. We're sure where to start. The data's not well normalized, that it's patchy, it's bare, it's not just evenly, and then we look to what we could reasonably get for analytics, much less an app or
So again, the stars align, and I would tell you, let me line down the players. Nancy Gertner, who left the federal bench in Boston and is now running of the Legal Institute at Harvard. I've presented in her sentencing class, is really a leader in all these fields, and I really admire her. Leo Sorokin, who is a magistrate judge, senior magistrate judge on Boston, has now been nominated to be in Article 3. And with me, there's a whole group of us, but he started his program. They call it, it's a CARES program. Everybody names theirs differently. So he's a leader and he's in Boston. So those are two. Mark Sherman, who's at the Federal Judicial Center, is the keeper of all of this, a lawyer, trainer of all the judges and probation officers. I would tell you Charles Samuels, right now the director of the Bureau of Prisons, cares about this, a program guy, and will work with us. So you would build a team to look at the data, because when we first, if you went on the District of Oregon website under probation, what we did, which I have to say, looking back, I couldn't believe we did it, to put a program up in the federal system when they didn't do it, is the team of us read 4 bodies of literature. And we went back to those core components that needed to be in place. And it's using what I would call the Kennedy School of Government, and that is you take the best practices, you put it up, and then you fine-tune it. And that's their model of public policy. So we did that. And then we've continued to fine-tune it. But we didn't even keep the data in probation back then. So we had to go through files to try to even have a comparable group. So I know the data problem is really hard. That's why if we started with this population where we get the intense data and build back. So now we have what's called the PACS system in the probation office. So we're starting to keep that data, and we're now in a program improvement model, and we are looking at how we're going to track that data better for just the courts. Then there's the prisons, and then there's sentencing. So I would tell you that we all work better in teams, cross jurisdictions, multidisciplined approaches, and that we could throw a lot of folks your way, including a third-year law student named Nick Meyer at Harvard, who's going to come back and clerk at U.S. District Court for Oregon for Judge Simon, also a Harvard grad. So we are a little Oregon. We're sending people back to the big city to learn some of this stuff and bring it back to the ranch, and put it.
You have a lot to teach us.
No, but we have a model. We're small enough we can do some of these models. But there's some great people around the country, and I could shout out to so many different folks in different districts. So it just is a question of what do you think would be a good team, and we could do conference calling and make some things happen.
Thank you. And then in closing, I just encourage you to say, in terms of date forward, looking at all the data in the past in the system that's today, take a look at front. And we don't talk again for some reason, is the network that gets ridiculously deep data on mobile phone use for science, all the sensors on the smartphones. And from the we're able to discover who's like that depression, those traumatic stress syndrome is part of the curriculum or advanced system. It may even meditate from these apps. If you use these types of sensor arrays, it would be even more predictive when someone that's
including all of our folks. And they would come and they would get to prove how hard they would work. They would meet people. They just had a place to go. So as a part of our reentry program is to create pro-social activities and programs. Pensacola, Casey Rogers, who runs the reentry court in Pensacola, has a phenomenal garden that she runs. Dolly G they have a diversion upfront program, because what our hope is we get to a point where we're really doing evidence-based sentencing. So right up front, we're able to make better decisions early on and use our resources in a more strategic way. But what I would tell you from a standpoint of making decisions, federal judges had the authority to do this at the back end. Because up front, a prosecutor decides who gets to get in those programs. At the back end, they're all coming out and they're under the jurisdiction of the judges. So we built our system at the back end because you can't just ask a system to business pop up. You have to build that there's a demand and a need. And so we've been building the back end system to move to the front. And what I will tell you is all the model that we're building at the back end for the highest risk offenders using the most expensive resource, a federal prison bed, is built on the strategies that we use for children at a risk of abuse and neglect in a family-centered, holistic, wraparound service model. And wouldn't it be nice if we're working both ends towards the middle where we have a different outcome with our resources and our data? So thank you for asking. Yes, ma'am.